Please pay close attention to this. In essence, this, dare I say, a tutorial on grand juries and the like. The breaking news is that U.S. Attorney General Pam Bondi is demanding that the Epstein grand jury files be unsealed and made available, and everybody should get to know what's going on here. And the court responds with a few conditions. And this is critical, and everybody should understand this and grasp this idea. First, in what some consider to be dramatic, but not really unprecedented, the U.S. Attorney General Pam Bondi, former Florida Attorney General, who first made national headlines for her tough stance on corruption and child exploitation, is now demanding the full unsealing of grand jury records tied to the Jeffrey Epstein investigation. And the court has responded. Here's what the court said. This is what's important. The court that Pam Bondi petitioned, ordering her office to provide the following with more specificity before it grants any type of grand jury release. Pam Bondi must show and must now identify which grand jury transcripts and materials she seeks to unseal, and supply supporting statements and documents from the Epstein victims who would be directly impacted by the public release. It's a cautious green light, not an outright denial, but it indicates the court is open to the idea, but only if Bondi plays by the rules laid out in binding federal precedent. And I concur wholeheartedly. This case could prove to be one of the most consequential transparency battles in modern legal history, pitting the current Attorney General of the United States against decades of entrenched and established secrecy at what critics have long called the Epstein Protection Network. Now, Bondi's motion, or the Attorney General's motion, the DOJ's motion, centers on unsealing grand jury records from proceedings in Florida and New York tied to Epstein's original 2006 to 2009 non-prosecution deal and other related federal matters. Her office now is she's claiming that the material that's contained in this evidence and that she wants to see is evidence of government misconduct, procedural fraud, and the intentional suppression of criminal referrals. That, she says, may implicate still unnamed individuals. So obviously it's very, very critical. Now, the legal framework, which is important about this, the legal framework governing the release of this grand jury material comes from the 1997 landmark case of In re Craig. It's a 1997 Second Circuit case in which the Second Circuit, which is the intermediate appellate court that handles the Southern District of New York, it established 9 guiding factors for judicial discretion in whether to unseal decisions. Among those are the identity of the petitioner, the opposition of the government or defendants, the reason for the disclosure, the specificity of the request, the time elapsed since the proceedings, the status of the individuals involved, the public availability of the material, and whether the witnesses are still alive and whether continued secrecy serves any valid purpose. Because remember, if you violate or contaminate or ruin the bases of secrecy, why even have grand juries? On nearly every point, Pam Bondi's case appears designed to satisfy that test. Now, acting as the top federal law enforcement officer in the United States, Pam Bondi is not only legally entitled, but arguably obligated to ensure justice was served or wasn't obstructed, especially in a case that shook the pillars of global confidence in the American justice system. Now, her office right now is arguing that the public and the public interest in the Epstein matters is overwhelming and urgent, given what they allege, and I believe, are years of misdirection, cover-ups, sweetheart deals, all that silence victims and protected elites, and causes you to lose faith in the system. Her official statement, Bondi declared that the American people have been lied to, misled, and deliberately kept in the dark. My office, she writes, will not rest until the full truth behind the Epstein cover-up is made public and those responsible are held accountable, no matter who they are. Now, the push, as you can imagine, has generated immense public attention and online momentum. And the public, journalists, and others posted various things on X. So the question is simply this. Does she have a leg to stand on? Yes. What is the reason for her not to make this available? The reason why is very simply this. The reason for the grand jury versus the petty jury is to ensure that investigations are held secretly, quietly, and to protect witnesses, protect people who haven't been charged, but to provide the basis as a buffer between the sovereign and the people. It's not merely to let you know how the government works, how it investigates, what it investigates, because believe it or not, that is not necessarily something that you have a right to know. It has to do, believe it or not, with whether this serves any purpose. My suggestion is very simple. Do this quietly. Don't announce to the world what you're doing. You're better able to get a solution that is amenable without causing people's attention, without making courts aware of this. Do it secretly. Do it quietly. And do it outside of the province of Fox News. Because everything right now is on Fox News. Act secretly. Remember, you're a cop, the nation's top cop. You're not a podcaster anymore. You're not somebody trying to win the hearts and minds of MAGA or CPAC or red-blooded Americans. You're the Attorney General representing justice, representing the people. So you can do this. And I think you've got a lot of room to stand on. But do it by the rules. Do it carefully. Do it judiciously. Do it quietly. Do it discreetly. And now comment as you see fit.